How many jurors do we have? Do we have both groups?
You're gonna go check that.
Okay, thank you. Seat 40 from seat 40. Okay, that's going to be. Is that the only one we're missing? All right. Well, we'll try to hunt down that juror, but in the meantime, let's bring the rest of them in. Try and get started.
We're gonna do 1:30 and 2:30 together, 3 o'clock. Sir.
This way. All right, welcome back, folks. If you raise your right hand, we're going to re-swear you in. Have a seat, everyone. All right. Welcome back. This is the second part of voir dire, jury questioning. I'm sorry to the 1:30 group. We are running a little bit behind, but we should be able to get you out of here at a reasonable hour today. Can everyone hear me when I'm wearing this mask? You can't hear me? All right, can you hear me now? Better? Would you like a hearing aid, sir? Let's give you a hearing. Juror in seat 42, can you hear me now, ma'am? A little bit better? Would you like a hearing device? Okay. For the record, I've removed my mask to see if the jurors can hear me better. All right, I have the mask back on. Can everyone hear me clearly with the mask on? Anybody having any problems? Need me to take it off? Great. All right, we're going to be asking you, I'm going to be instructing you as a group, and then we're going to send you back into the jury room and start bringing you out one at a time to ask you individual questions. Before we do that, I want to give you an overview. Okay. I have one more juror coming up, so I'm going to wait until they get here so I don't have to repeat myself. Sorry. You can just seat them right on the end. Thanks. Now that we're all here, I'm going to be explaining to you a little bit more about how these cases work and giving you some preliminary instructions. I'm going to give you some facts on the case, and then we're going to start questioning, all right? So let me start by telling you this is a capital case, and it's a capital case. We call it that because there is a possibility of a death sentence in the case, so it's just called a capital case. In this case, Mr. Loyd is charged as follows. By the way, he's charged by indictment, which is a piece of paper. I have a copy of it here in my hand. This document just tells someone what they're charged with. You have to tell people what you're accusing them of doing. Florida does it this way. You cannot use the fact that someone's been indicted or charged with a crime as evidence that they're guilty of that crime. This is not evidence. All right. In this case, Mr. Loyd has been charged with count 1, first-degree murder with a firearm of a law enforcement officer. Count 2, attempted first-degree murder with a firearm of a law enforcement officer. Count 3, aggravated assault with a deadly weapon. Count 4, carjacking with a firearm. And count 5, possession of a firearm by a convicted felon. The first count, first-degree murder of a law enforcement officer, is the only one in which the death penalty is a possibility if he is convicted. All right, these cases are tried in 2 phases. The first phase is the guilt phase. The guilt phase is what, if any of you have ever served as jurors, is the trial to determine whether or not someone is guilty. The guilt phase is conducted the same way as we do in all criminal cases. You will be asked to return a verdict of guilty or not guilty on all counts, and your verdict must be unanimous on all counts, meaning each juror must agree on each count either to acquit or convict. The burden of proof for the state is the same in the guilt phase of a capital case as it is for every other type of criminal case. It is proof beyond a reasonable doubt, and the instruction you will receive on reasonable doubt will be identical to the one that's given in all other criminal cases. The burden on the state is not higher because of the possible penalty. When you're deciding guilt in phase 1 of the case, you will be instructed to ignore the possible sentence during this phase. In other words, we ask jurors to decide whether a defendant is guilty or not on the charges, including first-degree murder, on their own merit, and you will be told to disregard the possible consequences of your verdict. The only question you are to answer during the guilt phase is whether the defendant is guilty of murder in the first degree, as well as any other offenses charged, or guilty of a lesser included offense, or not guilty. And we expect you, as a juror, to carefully consider the facts before you reach a decision. The fact that a defendant might face a death penalty is to play no part at this stage of the proceedings. If and only if a jury returns a verdict of murder in the first degree, the jury will reconvene for the purpose of rendering a verdict as to which sentence, death or life imprisonment without possibility of parole, should be returned. If that happens, a special set of rules and instructions come into play. And I'm going to give you an overview of that stage right now. That's called the penalty phase. I also want to tell you that in the state of Florida, life without the possibility of parole means exactly that. The defendant will die in prison. We do not have parole in this state. Because the death penalty is reserved in Florida for only one class of crimes, and that is murder in the first degree, the legislature has created special rules for juries to consider in reaching a verdict in the penalty phase. The legislature recognizes that not all first-degree murder cases deserve the death penalty. So they created a list of circumstances which juries are to consider in reaching a verdict in a death penalty case. The prosecutors are going to rely on something called aggravating factors. The state is required to prove these factors beyond and to the exclusion of a reasonable doubt. They are limited in number by statute. And these are the legal reasons the state believes the death penalty is the appropriate sentence. The defense relies on something called mitigating circumstances or mitigators. These are reasons that they believe the appropriate sentence is life without the possibility of parole. Mitigating circumstances do not need to be proven beyond a reasonable doubt. A mitigating circumstance need only be proved by the greater weight of the evidence. Mitigating circumstances are not limited by statute, and they may include matters that are relevant to the defendant's background or character or circumstances surrounding the offense, and they will be offered as a basis for a verdict of a sentence of life in prison without parole. Before you may vote the court impose a sentence of death, the state must prove one or more aggravating factors beyond a reasonable doubt. The process of weighing aggravating factors and mitigating circumstances to determine the proper punishment is not a mechanical or mathematical process. In other words, it's not your job to add how many aggravators there are, add how many mitigators there are, and say, oh, it's math. That's not how it works. The law contemplates that different factors may be given different weight or values by different jurors. In your decision-making process, you and you alone are to decide what weight is to be given to a particular factor. Regardless of your feelings in this respect, however, you are never compelled nor required to vote for a sentence of death. The final step in this phase of the trial is for each of you to determine whether the defendant should be sentenced to life imprisonment without the possibility of parole or death. The court may not impose a sentence of death unless each juror individually finds the defendant should be sentenced to death. In other words, the verdict for death must be unanimous. Even when death is a possible sentence, each juror must independently decide whether life imprisonment without possibility of parole or death should be imposed. Regardless of your prior findings, the law never compels nor requires any juror to determine the defendant should be sentenced to death. Any single juror has the right to vote for a sentence of life imprisonment without the possibility of parole. If after deliberating, the jury unanimously agrees that the appropriate sentence is death, then your verdict may be for a sentence of death. If the jury does not unanimously agree that the appropriate sentence is death, then your verdict must be for life imprisonment without the possibility of parole. This is really a very broad outline of the penalty phase. I just wanted you to kind of get an idea of what you'd be asked to do as jurors. Detailed instructions are provided to jurors along every step of the case. Let me also emphasize and say this to you all. The fact that I'm talking about the death penalty is not to be taken by you as an indication one way or another as to whether or not this case justifies a death penalty. I don't know that, and you don't know that. I'm only discussing it because it's a possibility, and we need to know that you can do your job if this should become a factor in this case. We're going to be asking you some questions about the death penalty. I'm going to tell you what some of them are, just so you have a chance to think about it a little bit before you're out here answering questions. We're going to ask you if you have any religious or moral objections to the death penalty, whether you're someone who thinks death should automatically be a sentence for someone who's convicted of first-degree murder, or whether you can accept the premise that a sentence of death is not appropriate for all first-degree murder cases. You're going to be asked about whether you can weigh aggravators and mitigators in determining whether or not life or death is the appropriate sentence. And you may be asked whether you're so opposed to the death penalty that you can't impose it regardless of what the law says. Many people have very strong feelings about the death penalty, both for and against it. The fact that you have such feelings does not disqualify you to serve as a juror, as long as you can put those feelings aside and apply the law as I instruct you. In other words, you must be willing to be bound by your oath as jurors to obey the laws of this state in delivering your verdict. Additionally, I want to advise you that Mr. Loyd, in this case, has raised the defense of not guilty by reason of insanity. I'm going to read you a very short portion of the insanity instruction. If you're on the jury, you would hear this at the end of the case. And insanity is the one time, the burden of proof is normally on the state of Florida beyond a reasonable doubt, but with the defense of insanity, the burden is on the defense by clear and convincing evidence to prove this. And what they would have to prove is a person is considered to be insane when he had a mental infirmity, disease, or defect. Because of this condition, he did not know what he was doing or its consequences, or although he knew what he was doing and its consequences, he did not know it was wrong. Like I said, I'm just giving you the basic definition of insanity. So we're going to be asking you some questions about whether you can listen to that defense with an open mind. And lastly, I'm going to read you a statement about some of the facts of the case. And we're going to have questions for you about some of this, all right? On the morning of January 9th, 2017, defendant Markeith Loyd is alleged to have entered the Walmart store at 3101 West Princeton Street. Mr. Loyd had an active warrant for his arrest. Orlando Police Lieutenant Debra Clayton attempted to take Mr. Loyd into custody on the information she received regarding Mr. Loyd's involvement in the Dixon homicide, when it is alleged Mr. Loyd shot and killed Lieutenant Clayton following an exchange of gunfire before fleeing the Walmart and eventually being apprehended about a week later. Mr. Loyd's trial for the killing of Sade Dixon and her unborn child began on September 27, 2019, and concluded on October 23, 2019. Mr. Loyd was convicted and sentenced to life without the possibility of parole. This last portion I just read to you about the conviction on Ms. Dixon, that cannot be used by you. I'm instructing you that you cannot use that conviction as evidence of guilt in this case. That evidence is being offered for a different reason that the jury will be instructed upon later on if you're on the jury. But you have to be able to put that aside and not use it as evidence of guilt in this case. All right, folks, having read all that to you, I now have, as a group, a couple of questions for you. And all I need you to do, please, is hold up your paddles in response. Don't say anything. How many people have heard about this case? All right, when I call your paddle number out, you can put them down. 8, 13, 16, 20, 22, 26, 29, 35, 36. The next one, you're slightly turned. 41, 42, 43, and 40. All right. For those of you who've heard something about this case, how many of you have formed an opinion, don't tell me what it is, have formed an opinion as to Mr. Loyd's guilt? 8, 13, 26, 35, 36, 42, and 43. All right, ladies and gentlemen, thank you very much. I'm going to send you back into the jury room. 8, if you'll stay here in the courtroom with us, we'll start with you, questioning. First seat, first one. The rest of you go on into the jury room. There's coffee in there. Try to relax. Don't talk about the case, but think about the questions you're going to be asked. We'll bring you back in as soon as we can. All right, sir, while they're all exiting, you're juror number 557, correct?
Correct.
All right. Welcome back.
Thank you.
Has anybody talked to you or said anything to you about this case since you were last here on Friday?
Yes.
Who?
The wife, the neighbors, some family members. I knew that I was coming here Friday for this reason, so.
So did they talk to you before you came here?
Yes.
Did they talk to you afterwards?
Not directly, no. I did as you instructed.
Right.
Just said I can't talk about it and left.
So they went off and talked among themselves?
No, they really already knew at that response
Okay.
that I was going to be here, and yes, that's why I'm here. So but I left it at that. I can't talk about it, so that's how it ended up.
Over the years, have you all talked about this case since it happened?
Yes.
And how much coverage of this did you watch?
Did this die? Okay. I worked at the Sentinel and was in the press room. We saw the pages as they were coming out before they went on to the press. My responsibility was to get those presses up. On several instances, we had to hold those presses, wait for additional information to come in. So we were all just standing around reading that information as it was coming in.
Okay, so you were in the thick of this.
In the thick of it, yes.
All right. And did you keep up with it after that?
Yes.
All right. How long did you work for the Sentinel?
Almost 40.
All right. You said that you had formed an opinion as to Mr. Loyd's guilt.
Correct.
Can you tell me what that opinion is?
Well, I don't know how to say it, but yeah, I think that under those circumstances and the way that it was, presented to me and what we read and saw and heard on all the media and everything, that, yeah, I knew he was guilty.
Okay.
Yeah.
In order to sit as a juror, you have to presume he's innocent until and if the state proves he's guilty beyond a reasonable doubt. Do you think you can do that, or you pretty much decided? Look, we're not looking for one answer or another.
Okay.
I know we're putting you on the spot, but you just need to tell me the truth.
It feels like it, but no.
You think he's guilty?
I do.
All right. Any objection, state?
No, Your Honor. No
Defense?
objection, Judge.
All right. All right, sir. Thank you for your candor. We appreciate your service. Enjoy your retirement from the Sentinel. You're still working, so
No, I am retired.
enjoy your retirement. You're free to go.
Thank you.
But the mask is a gift from us to you.
No, I would rather leave it.
Thank you, but no. All right. Juror in seat 13, please.
Sorry, 13?
13, yes. This is juror number 590, I think. I should put my glasses on. Good afternoon. You're juror number 590, is that correct?
Yeah, that's correct.
All right, you were supposed to find out from your employer whether they were going to pay you if you got picked for the jury for 3 weeks. Did you
Yeah,
find
they
that
will.
out? They will pay you? Okay. You also told me that you had heard about this case and that you had formed an opinion as to Mr. Loyd's guilt. Is that correct?
That's correct.
How much did you hear about the case?
I heard about the girlfriend and the two officers.
All right, did you, you said 2 police officers? Okay. You got to get that mic closer because we can't hear you. All right. So did you follow the case throughout the years or just when it first happened?
No, when it first happened.
Okay. Have you followed anything since then?
No, not really. There's too many things going on.
All right. Did you form an opinion as to whether or not Mr. Loyd's guilty?
Yes,
And what is that?
I think he is.
You think he's guilty?
Yes.
Okay. In order to sit as a juror in this case, you have to be able to presume he's innocent until the state proves he's guilty beyond a reasonable doubt, if they do. Can you do that, or are you going to be sitting there thinking he's guilty?
It's going to be a tough one,
So you're going to think he's guilty?
most likely.
All right. Thank you, sir. State?
No objection. No
Okay.
objection, Judge.
All right, sir, this isn't the case for you. I appreciate your willingness to serve, but you're free to go.
All right.
Juror in seat 26, please. This is juror 659. Good afternoon, ma'am. How are you?
I'm well. How are you?
I'm fine, thank you. Okay. Ma'am, you indicated you'd heard about this case.
Yes.
How did you hear about it?
I was a juror in 2019.
You were a juror on the first trial?
Yes.
Any objection from state?
No, Judge.
Any objection? I don't know what the odds of that happening are, but thank you so much for your service. You're excused. I think you did your duty last time. Thank you very much. The juror in seat 35, please.
I'd like to say something first, if I could.
Okay,
Something I did not know on Friday.
okay,
I have a letter here from the director of surgery. I cannot serve. There's a person, a third person at work that's going to take a leave of absence that I did not know.
okay.
Nobody can do my job.
All right, I've got that letter. Let me ask you a couple questions first. You said you heard about this case, is that correct?
Yes.
How did you hear about it?
Well, on the news.
Okay.
I remember the pregnant woman.
Okay. How much did you hear? Did you follow it real closely or just,
No. I mean, what I hear.
all right. But you said you had formed an opinion about whether he was guilty or not?
Well, yeah, I did.
It's okay. You're not the only person who said that to us, so what's your opinion, ma'am? You think he's guilty or not guilty?
I would have to say, I feel terrible saying this, but what I've heard, okay, yes, I think he is guilty.
Okay.
If the officer is dead and it's him that killed her, well, yeah.
All right. Do you think that's an opinion you could put aside and have an open mind, or you think you're pretty?
Yes. I'm mature enough to know I've got to listen to everything and.
Okay. So would you be sitting there in the trial thinking, all right, I'm willing to have him convince me that he's not guilty? Or would you be thinking the state needs to prove to me he's guilty?
No, the state has to prove.
Okay. All right, state.
We move, Judge.
We agree.
All right, ma'am, I'm going to excuse you from service in this case. Thank you, we appreciate you coming in. Good luck to you. Hope things go well.
Thank you.
You're discharged. You can keep that mask.
Do I go home?
Yes, ma'am, you're free to go. You don't have to come back anymore. Thank you, ma'am. That was juror in seat 35. Yeah. All right, I need the juror in seat 36, please. Yeah, the one that was just excused is in seat 35, 579, and all of these folks are on panel number 3. All right, ma'am, good afternoon. How are you?
I'm good. How are you?
I'm well, thank you. Just have a couple questions for you right now, which is this. You said you'd heard about this case, is that correct?
Yes.
How did you hear about it?
On the news.
How much did you hear about it?
Quite a bit. Living here in Orlando.
All right, did you follow it from the beginning?
Can you repeat that? I'm sorry.
Did you follow it from the beginning?
Yes.
All right, and have you followed it through the years?
Not since 2019.
Okay. So as a result of that, did you form an opinion as to Mr. Loyd's guilt?
Yes.
And what is that opinion?
Guilty.
All right, ma'am, jurors have to be able to have an open mind about the case, and they have to presume that Mr. Loyd is innocent until and if the state can prove him to be guilty. Do you think you could do that?
No.
All right, state.
State moves.
Agree.
All right, ma'am, this is not the case for you, but we appreciate your honesty and your willingness to serve. You are free to go and discharged as a juror in this case. Juror in seat 42, please. That is juror number 522. Is it the Hawk?
Yeah.
Yeah. Is he trying to get in again?
Yeah.
Yeah, he's trying to bust in. I don't know why he does that. All right.
Unless they're trying to get out.
All right, ma'am, just to confirm, your juror number is 522, right?
Yes.
All right. Ma'am, you indicated that you knew something about this case, is that correct?
Yes,
Can you tell me where you heard information about the case?
mostly from reading it in the past and recently before I've been knew about jury duty in the newspaper, as well as I have a couple of very good friends that are retired from the police force, and we talked in the past.
Which
about it.
police force?
Orlando Police Department.
And did they know Lieutenant Clayton?
Yes,
And did they talk to you about all this?
yes, yes.
All right, so based on all of that, have you formed an opinion as to whether or not Mr. Loyd is guilty?
Regardless of talking with them, I have my opinion.
Well, no, I didn't mean
Oh,
based
yeah.
just on the
Yeah.
conversations. I'm saying based on everything that you've
Yeah.
heard and read and all of that.
Yes.
Do you have what is that opinion, ma'am?
Guilty.
All right. Is that something that you think you could set aside and presume him to be innocent?
I have not been able to be without anxiety since Friday. I don't
right.
think that I can do this.
No worries, ma'am.
Okay.
State moves, Your Honor.
Agree.
All right, ma'am. This isn't the case for you, but we
Thank you.
appreciate your honesty and your willingness to serve. You are excused as a juror.
Okay.
Thank you.
Thank you very much.
Juror in seat number 43, please. And this is juror number 566.
I'm sorry, Judge.
Juror number in seat 43. Yes, please. Good afternoon, sir.
Good afternoon.
Your juror number is 566, right?
That is correct.
All right, so you indicated you'd heard something about this case. Where did you hear?
I've been in Orlando for quite a while. There was extensive media coverage on this during the manhunt and all of those phases.
All right, do you follow the local media pretty closely?
Not me, but my spouse.
Okay. Based on everything you've heard, did you form an opinion as to Mr. Loyd's guilt?
Yes, I did.
And what is that opinion?
I think he's responsible.
Okay. So you believe he's guilty of the charges?
Yes.
Okay. Do you think that's something you can set aside and presume him to be innocent, or you have some doubts?
No, I wouldn't be able to do that.
All right, thank you, sir.
State moves, Your Honor.
Any objections? All right, sir, I don't think this is the case for you, but I do appreciate your willingness to serve. You are discharged as a juror in this case, and you're free to go. Thank you. You can bring in the juror in seat 23, please. I have an indication that this lady is caretaker for an elderly mother, so I'm bringing her in to talk to her. And I don't remember who told me, so. It's not that one? This never ends well. 723? Oh, seat 22. All right, I missed the seat by one. Okay. Hi, how are you?
Okay.
I'm sorry, I hate to do this to you, but I actually need the juror in seat 22. I'll be right with you. I'm so sorry. I want to make sure all of you get your steps in today.
I need,
Seat 22, sorry, folks, juror 723. Good afternoon, ma'am.
Hello,
How are you?
I'm doing well. How are you?
I'm fine, thank you. Ma'am, I was told that you take care of your mother, is that correct?
Correct.
How old is your mother?
My mom's 89.
And are you her sole caretaker?
My sister and I do probably 75% of it. I can leave her alone at night up to maybe 3 to 4 nights. She doesn't have full-on Alzheimer's, but she gets a little wigged out if she's by herself at night after a few nights.
Okay, is there, I mean, you would be sequestered for 3 weeks. Is there
Right.
anyone who could take over for you?
I don't think my sister would do it for 3 weeks.
Okay,
I don't know, and I apologize to the defense, the prosecution.
it's all right, ma'am. Life is life.
Yeah,
Sometimes it's complicated. State,
We would move, Your Honor.
any objection? All right, ma'am, you go home and take care of your mom. We
All right.
appreciate your willingness to be here.
Sorry.
You're discharged, no problem. 22 is gone. Hold on, let me catch up here. All right, let me see the juror in seat 16, please. Good afternoon, sir.
Hello,
All right, sir, you're juror 877, correct?
that is correct.
All right. You indicated that you had heard something about Mr. Lloyd's case, is that correct?
Yes.
Can you tell me what you heard?
On Friday, before reporting to jury duty, I read the article in the Orlando Sentinel about jury selection and the article on Wesh.com.
All right. What do you remember about that article?
Not any more than what you told us about 15 minutes ago when you read the indictment.
Okay. Is there anything about what you read? Well, let me back up a minute. Have you heard anything about the case?
And only those 2 articles and what you told us
Okay.
10 minutes ago.
Is there anything about what you heard, what you read, not what I told you, but what you read that that has led you to reach a conclusion about whether or not Mr. Lloyd is guilty?
No.
All jurors are required to be able to presume Mr. Lloyd to be innocent until and if the state can prove he's guilty beyond a reasonable doubt. Do you think you can do that?
Yes.
All right. All right, I'm going to ask you a few more questions, and I'm going to turn it over to the lawyers. I will tell you, sir, that we're not looking for any particular answer. There are no right or wrong answers to these questions. We're just looking for you to tell us what you actually think and feel, all right? Have you ever thought about the death penalty prior to today?
Yes.
Do you have a religious or moral objection to the death penalty?
Not a religious or moral.
You have a moral objection to it?
I do.
All right. Could you ever impose death in a case?
I believe yes.
Okay. So let me ask you a couple of more in-depth questions. Let me ask it this way. Is there any case where you think, you believe that the death penalty should be the automatic sentence if you're convicted of that murder, that specific type of murder?
No, I do not.
All right. Are there any cases, no, forget that. You heard me describe the process in the penalty phase. The state's going to present evidence. It's like another trial. The state's going to present evidence of their aggravators, the reasons they believe death is an appropriate sentence. And this, of course, presupposes Mr. Lloyd's been convicted. We do that for purposes of this discussion of first-degree murder. The defense then presents evidence of mitigation, the reasons they believe that life is the appropriate sentence without parole. You have to be able to listen to both sides with an open mind. Then I'm going to give you the jury instructions. You go into the jury room with your fellow jurors. You're all going to talk about this among yourselves. If at the end of that, you weighed the aggravators and the mitigators, you listened to everybody, you've talked about it as much as you want to, and you're ready to make a decision, you've weighed everything, and you believe that the evidence and the facts lead you to a sentence of life without the possibility of parole, can you vote for that?
Yes.
And if you believed that the evidence and the facts led you to a sentence of death, could you vote for that?
I don't know.
Okay. So you have some doubts about whether you could ever impose death?
Yes, I do. In a case like this.
What do you mean by in a case like this?
You asked me about could I ever, in cases of genocide? Yes. For a case like this, from what I've heard so far, I'm not sure.
All right. Let me ask you about the defense of insanity. Mr. Loyd's raised that defense. Is there anything about that that would indicate, if at the end of the guilt phase, this is when you're trying to decide whether he's guilty or not, you felt that the defense had proven by clear and convincing evidence that he was insane at the time of the offense, could you vote not guilty?
Absolutely.
And can you follow my instructions about not considering the conviction for the murder of Sade Dixon and her unborn child and that life sentence, not considering it as evidence of guilt?
I would not consider it.
So your sole concern in this case is that you are not sure if you could ever impose a death sentence for this type of case?
That is correct.
All right, thank you, sir. State, you wish to inquire?
We don't have any questions.
All right, defense, go ahead.
How are you doing, sir?
Okay, thank you.
So I understand the kind of the final conclusion, but I need to understand why. The final conclusion being you don't know if you can ever vote for the death penalty in this kind of case. Tell me why.
Pragmatic grounds as well as moral ones.
Okay.
On the pragmatic side, I don't believe it is effective as a deterrent. I think it's not efficient as a bargaining tool. I think it is actually not efficient in terms of resources, and on moral grounds, I think it lowers us to a level that I think a civilized society and our neighbors and other friends don't.
Okay.
Do.
What do you teach?
May I answer that question indirectly?
Yes,
Your
sir.
Honor?
Indirectly. Sir.
By answering questions regarding where I work and what I do and what my title is,
Yeah, I'm
I'm
not gonna-
clearly identifying myself to the public.
Absolutely. I'm not going to do that.
No, just limit it to subject matter only.
General.
Yeah.
Generally, research methods, statistics, and psychology.
Okay. Now, do you believe it's important for the defendant to have a jury of his peers?
It is the law of the land.
And so what the law says is that you never have to vote for death. There is actual provision in the jury instructions that say you never have to vote for death. But you have to be able to consider the possibility of voting for death. And so by exclusion, anybody who can't do that cannot serve on the jury. So now there's a group of people who are completely against the death penalty under all circumstances. That's not you because you mentioned genocide, correct?
That is correct.
Okay. And those are excluded from listening in on his case and being part of the jury. Do you think it's important that Mr. Loyd have members of the community, even those who don't believe in the death penalty, but can follow the law?
I believe that's the principle
Okay,
that underlies the process.
okay. Being that that's the principle that underlines the process, I heard you say you don't think you can ever vote for the death penalty in this kind of case. If the law says you have to be able to consider the death penalty in this kind of case, could you do that?
I believe yes.
Okay. Thank you.
Either side need to approach?
Yes.
You ready? Okay. All right, sir, I appreciate your willingness to serve. We all do, but I don't think this is the case for you. So with our thanks, I'm discharging you as a juror in this case.
Thank
You're
you.
free to go, sir.
Yeah.
All right. Let's bring in the juror in seat number 9, juror 923. Good afternoon. How are you?
Good.
All right, you're juror number 923, correct?
That's right.
All right. All right, sir, I have a few questions for you, and then the lawyers are going to have some questions. There aren't any right or wrong answers to these questions. There's just the truth and what you think and feel. That's all we're looking for, all right? First of all, I just want to confirm, are there any issues with you serving on this case for 3
No.
weeks? No? All right. So, prior to coming in this courtroom, have you ever thought about the death penalty?
In college, we discussed it.
Okay. How long ago was college?
I graduated with my bachelor's in 2018.
Okay. Do you have a position on the death penalty?
I'm neither for or against.
You're neither for nor against it?
Right.
Okay, what do you mean by that?
I don't have any strong favor towards one or the other.
In these types of cases, if you got to a penalty phase, you have to be able to, with an open mind, listen to the state presenting their evidence of the aggravators, the reason they believe that death is the appropriate sentence. The defense is going to present their evidence, which is mitigators, the reasons they believe life without parole is the appropriate sentence. I'll give you the jury instructions. You then go back into the jury room with your fellow jurors, and you all can talk about it as much or as little as you want. It's really up to you how much you want to discuss it, but you're welcome to discuss it with them. You have to weigh these aggravators and mitigators, figure out what weight you give to them. And then in the end, you have to come to a personal decision as to whether or not you believe life or death is the appropriate sentence. If after all of that, you believe that life without the possibility of parole was the appropriate sentence, could you vote for that?
Yes.
If after all of that, you believe death was the appropriate sentence, could you vote for
Yes.
that? All right. Do you have any doubts in your mind about your ability to go through that process and vote whichever way the evidence and the facts take you?
No.
All right, you heard me talk about the fact that Mr. Loyd has raised the defense of insanity in this case at the time of the offense.
Right.
The burden's on the defense. So this is in guilt phase when you all are trying to decide whether or not he's guilty. If at the end of the guilt phase you've heard all the evidence and you believe that they've proven to you that he was insane at the time of the offense, would you be able to return a verdict of not guilty?
Yes.
And lastly, can you follow my instructions about not using the fact that I told you about the Dixon homicide and the child and the unborn child and the life sentence, you can't use that to determine guilt. Can you put that out of your mind while you're listening to the case?
Yes.
And reaching a verdict? All right, thank you very much. I don't have any other questions for you. State, you may inquire.
Thank you, Your Honor. Good afternoon, sir.
Hello.
So what class and what was the context in which this conversation about the death penalty occurred? If you
I
can
was
remember.
one class away from my African American Studies minor. In one of my education classes for African American Studies, we discussed the death penalty.
And what was the context? In other words, how was it brought up? Because I'm not seeing the tie exactly.
We were talking, and forgive me if I'm not recalling correctly, but in this class we talked about education, we talked about jail, prison, how it adversely affected minors, and then that's where we kind of got in the death penalty. It wasn't a class revolved around death penalty.
Right.
It was just a subject.
Okay. Do you remember what it was that you were thinking when the death penalty conversation arose? Even if it's in terms of the class and the topic at hand.
The only thing I thought of, maybe they did something that bad to deserve it.
Okay. Can you think of something that bad to deserve it? By it, I mean the death penalty as you sit here now. In other words, let me be more precise. A question or a factual scenario in your mind, a crime that was committed, a first-degree murder that was committed, where, I'm not asking you to tell me right now, but you can think of it either based on the way it happened or the nature of the victim, something about the defendant, where you think that death would be warranted if the law permitted it.
Could you rephrase that?
That was a long question. I agree. I apologize. As you sit here now, can you think of a first-degree murder and facts surrounding a first-degree murder that in your mind would warrant a sentence of death if it were proven beyond a reasonable doubt?
I'm not familiar with the definition of first-degree murder. I think maybe if there was a vehicular homicide with many people involved, I think
Okay.
that would warrant.
Multiple victims.
Correct.
Generally, not always, but generally first-degree murder is premeditated murder, which means that a person has thought about it, at least had enough forethought that they had the intention of the intended consequence was the death of the other individual. Does that help a little bit?
It doesn't change my mind.
Okay. So would it have to be a scenario where there were multiple victims, or could you imagine a different circumstance where the
I guess
crime...
it would depend on the circumstance of the case.
Okay, fair enough. Could you also imagine a set of circumstances where even if a person intended to commit murder, and we'll just take it a step further and say planned it, where even that crime would not warrant a sentence of death?
Can you repeat that?
Sure. So you told me a scenario where you believed a sentence of death might be warranted.
Right.
I'm telling you, I'm asking you to envision a first-degree murder where a person not only thought about it, but planned the death of the other individual, carried it out. Even in that circumstance, could you envision a scenario where you would think that life would be an appropriate sentence rather than a sentence of death? Life in prison without
I
parole.
think both have merits to the argument.
Okay. And I take it that you'd want to know more about the circumstances surrounding the incident.
Correct.
Okay. On a scale of 1 to 10, with 1 being you never think the death penalty is appropriate, and we know you're not there because you've told us,
Right.
and 10 being that you think it's appropriate for every first-degree murder, where would you put yourself as to how often you think a sentence of death should be appropriate or is appropriate?
Well, I would say that's very circumstantial. Like it would depend on the circumstances of the case. As far as this case, I would say maybe out of 5 right now. I'm not sure.
Okay. And when you say this case, you're basing that on the limited information the
That's
judge
right.
has given you. All right. Anything about the fact that the victim in this case was a law enforcement officer that you think would prevent you from being fair and impartial?
My father was law enforcement. He retired.
Right.
I'm not sure if that would affect my impartiality.
Okay. Was he local here
No, he's in Georgia.
in Georgia? All right. So again, there'll be evidence that the individual, the victim, was killed in the line of duty. Okay. Are you going to be able to set aside the knowledge of your father's profession and his career and make a decision based only on the information that you have from the case?
Yes.
Fair enough. Did you say that African American Studies was your minor or your major?
I was one class away from it to being my minor.
Okay.
Sorry, can you move that mic closer?
Sorry.
I'm asking because I saw your profession is listed as analytics.
That's right.
So I was trying to make the tie-in. What was your major?
Math was my major.
Math. Okay, gotcha. Did you take any classes, and I'm only asking because you're relatively young compared to some of us, and you were in college in 2018. Did you take any classes in psychology or anything like that?
No, not psychology.
Okay.
Sociology, yes.
Okay. The judge indicated to you and everyone else that the defense, one of the defenses in this case may be the defense of insanity.
Right.
And she gave you a definition of it, but the bottom line is if a mental illness is proven and the other facts are established, then under the law, Mr. Loyd would not be not guilty or not responsible for the crime, even if he committed it. Does that make sense?
Yes.
Anything about that fact that you think would prevent you from fairly and impartially weighing that defense?
No.
And the reason I ask is because some people have said, and you may have heard something like this, mental illness is bogus, I don't believe in it, people are just raising excuses. I see you shaking your head.
I work at Disney. I know that's not the case.
Okay. Have you or anyone close to you struggled with mental illness?
My partner struggled with PTSD, but that's it.
All right. Did he or she seek treatment?
Yes.
Does he or she take any medication?
No.
Okay. Do you believe that the treatment has been helpful?
Yes.
Okay. So you certainly have firsthand experience that mental illness is real.
That's right.
Okay. Is there anything about your background, life, or experiences that you think we should know about you, given that we're trying to select the most fair and impartial jury we can to hear this important case?
I don't think so, no.
Usually if there's something in like that, it pops into your mind. Okay. Thank you very much. Thank you, Your Honor.
Thank you, Mr. Willis. Mr. Lennon, you may inquire.
How are you doing, sir? So with math as your major, and I saw what your job was, are you the kind of person who's very structured in your thinking and compartmentalized, or?
Well, in my job, I'm a data scientist, so I have to find solutions.
Okay.
I'm not a-
Okay. Okay. And how much does that bleed over to your personal life and thinking? That kind of thinking. Is that the way? Okay. So if you were going through a checklist of what is required in this particular case, that's how you would do it?
Right.
Okay. Now, I know you had told us that you are neither for it or against it, and you had the one class. But what do you generally think?
I have never seen in my somebody that I followed closely on the news got the death penalty.
Okay.
I don't know. If something warrants that, then I agree it would warrant it.
Okay. So the one concern that kind of blew up in my mind was the fact that your father was a law enforcement officer. and we have a law enforcement officer here. So usually when you have that generally, people go, oh, you know, he's from a law enforcement family. He's going to look at the police differently. He's going to give the police more credibility, more sympathy, more empathy. Not saying you shouldn't, but just based on your father being a law enforcement officer. Do I have to be concerned about any of that?
No.
Did you have a good relationship with your father?
I still do.
So he's retired,
He is.
and you said he was in Georgia.
Yes, he was a sheriff.
Okay. Why did you choose your minor?
I'm sorry, what was
Why
that?
did you choose the minor that you chose? Was there a particular reason?
You said the motto?
Your minor in college.
Oh.
You said you had a minor in African American Studies?
There was no specific reason. I took one class. I really enjoyed the class.
Okay.
Majored in math. I minored in statistics. One class away from sociology minor, one class away from African American Studies minor.
Okay.
They were just electives I liked.
Thank you, sir. Now, I want to talk to you about a couple of things, and then we'll be done. You already said that you can consider insanity, correct?
Right.
It's proven to you. We have a burden of proving that. I want to go through with you right now some death penalty issues real quick. And I'm going to basically kind of be explaining how it works and what your role is, okay? So in order to sit on a jury to sit in a death penalty case on the issue of the death penalty, Mr. Loyd would have to be convicted of first-degree murder. Once that's happened, there's a penalty phase convened. There's opening statements, closing statements, witnesses called. The state would put on their evidence of what's called aggravating factors, which you heard about. Some of them may be from the original, this case. Some of them may be some other stuff, like you heard that my client was convicted of Miss Dixon's murder, okay? And the unborn child. That's going to be an aggravating factor in this case. So you would have to consider that, okay? You get to give whatever weight you want to it. It's all up to you. We will put on a case as well. We'll present expert testimony, family members, other stuff. Those are the mitigating factors. Aggravating factors have to be proven beyond a reasonable doubt. Mitigating factors, it's a lesser standard. They still have to be proven. Once they're proven, then you have to decide what weight to give the mitigating circumstances, okay? So once the evidence is presented to you, the first thing that happens is that the jury unanimously has to decide whether one aggravating factor was proven. Could be any aggravating factor. Doesn't have to be the same among jurors. You just have to feel that one was proven. That's the only time you do anything as a group. Everything else from that point on is individual decision making, okay? Because ultimately, it's your individual decision making on the issue of life or death, okay? So the next step you would take is that you would look at the aggravators that they provided you. You would see if they were proven beyond a reasonable doubt, give them weight, as we talked about. Same thing with the mitigation, okay? And then you would weigh the aggravators against the mitigators. And you get to give any value to any mitigator or aggravator that you want, okay? And once you weigh it, if you weigh them and you believe that the mitigation outweighs the aggravation, you must vote for life. If you find that the aggravation outweighs the mitigation, you may vote for death, but you don't have to, because there's a provision in law that says a juror is never required to vote for death under any circumstances. So if you decide the aggravators outweigh the mitigators, but you have your own reasons, whatever they are, to vote for life, you can do that, okay? So once that happens, then all the jurors would collect and tally their votes. In order for a death verdict to occur, it has to be unanimous. The jury has to be unanimous. If one person decides that life is the appropriate sentence, then it's a life sentence. You follow me?
Yes.
Okay. The other thing I want to talk to you about real briefly is that As I mentioned, this is an individual decision-making process. When you hear the jury instructions, it will tell you, you have to do as a juror individually this. It's your responsibility to do all the things I just told you about, okay? So it's your decision-making process. Now, you certainly can go back and talk to other jurors. You don't have to. You don't have to share anything with them. If you have an opinion one way or the other, that's your opinion. You just take it to the group when it's time to vote, okay? My question is, if you have an opinion, whatever that opinion is, and you believe in that opinion, are you going to let anybody kind of bully you into changing your mind?
That happens at work, and no, I don't.
Okay. Because sometimes what happens, because this is so emotional, there'll be people back there going, what are you, crazy? What are you, stupid? That happens all the time. We have a lot of studies that show that's done in death penalty cases around the country on a regular basis. You would not allow that?
No.
And would you protect other jurors when you see that right in front of you happening?
Yes, I would.
Okay. That's all the questions I have. Thank you.
Thank you.
All right, either side need to approach? I'll take that as,
No.
all right, sir, we're going to bring you back for the last round of questioning.
Okay.
And that means that you are now a purple dot.
Okay.
Okay, we're changing your color. Again, the color is just for reporting purposes.
Sure.
We're going to give you a sequestration package. And what that means is there's instructions in there for what happens if you're sequestered as a juror. We are going to pick the jury the day that you come back after some questioning. So you're going to need to have packed already. Leave your suitcase in your car. You don't need to bring it into the courthouse. If you get picked as a juror, we'll go ahead and have the deputies escort you out there to get it.
Okay.
Starting Friday after 5, we are not going to need you before next week. So starting Friday after 5, start calling the number that's on the slip of paper there. What you're listening for is the purple dots to return on this date at this time.
Okay.
I doubt it will be before the middle of next week, but you have to call every day just in case, because I can't really predict that with certainty.
Okay.
Have any questions?
You said 2 to 3 weeks for the sequester?
Yes.
Or you said?
You will be able
FaceTime?
to see. Yeah, you can talk. We're not trying to isolate you from everyone. You'll be able to bring your computer.
Okay.
You'll be able, as long as you're not on the internet looking at things about this case or anything like that, you can Zoom with friends and family. And we actually make arrangements for family to come see you.
Okay.
You know, spouses, partners, all that. So, okay?
Thank you.
All right, sure, no problem. Any other questions?
No.
All right, thank you very much, sir. We will see you when we call you back in. Well, let me get his information entered. And I'm going to need the juror in seat 14, please. Good afternoon, how are you?
I'm doing good, thank you.
I'm doing well, thank you. Sir, I want to go over a couple of things with you first, and then we're going to have some questions for you. The first thing I want to ask you is, you told us on Friday that you were not getting paid to be on jury duty, is that correct?
Yeah, so according to what I knew at that time, I gave the information that I wasn't getting paid. But when I went to work after that, I tried to clarify and ask if they would cover it or not. And they said that they would pay for it, but they didn't say for how long, so I'm not quite sure.
Okay. And if you're not getting paid, can you pay your bills?
Yes.
Okay. So do you have any problems serving as a juror in this case? If you were picked?
Not financially, no.
Not financially?
No.
Okay. Do you have any other problems serving as a juror in this case?
Nothing that would hinder me to serve. I just had an obligation on the 24th that I had mentioned earlier, but nothing that would actually stop me, like bills or anything.
Okay. So let me ask you a few questions. like I told you, then the lawyers are going to ask you some questions. Again, not looking for a particular answer. There are no right or wrong answers, just looking for you to tell me the truth and answer the lawyer's questions truthfully. You haven't heard anything about this case, is that correct?
That's correct.
All right. And how long have you lived in the Orlando area?
I've lived in the Orlando area my whole life,
Okay.
so 26 years now.
Did you hear any talk from friends or anybody about this case?
No.
No?
The only time I've heard about this case, I had told my manager that I'm serving I'm doing jury duty, or the selection or whatever, and they asked me, was it for the Loyd case or whatever? So that's the first time I heard it, and I had to tell them I can't say.
Okay.
But that's the first time I heard anyone talk about it, because I don't watch the news.
Good answer. I congratulate you on an appropriate answer to that inquiry.
Thank you.
So as you sit here, can you presume Mr. Loyd to be innocent until and if the state proves he's guilty beyond a reasonable doubt?
Yes.
Have you ever thought about the death penalty before this case?
I mean, yeah, I've had opinions on it, yes.
Okay. What is your opinion on the death penalty?
My opinion is that, like, if I was a lawmaker, I personally wouldn't put it into practice, but like in this setting, if someone were to be sentenced to death, I wouldn't be particularly emotionally swayed either way.
All right, so you personally don't believe in the death penalty? Or you personally don't think it's necessary?
Yeah, I don't think it's necessary, but I also don't strongly feel that it should be changed particularly. I just don't think it's necessary.
In this case, you heard me describe the process of a penalty phase, all right, which is the state's going to present evidence of aggravators, reasons they believe the sentence should be death. The defense is going to present evidence of mitigators, reasons they believe the sentence should be life without parole. At the end of this, I'll give you the jury instructions. You're going to go back in the jury room. You can discuss this with your fellow jurors as much or as little as you want. You have to weigh the aggravators and the mitigators, think about all the evidence, the facts. If at the end of that process you believe that life without parole was the appropriate sentence, could you vote for that?
Yes.
And if at the end of that process you believed death was the appropriate sentence, could you vote for that?
Yes.
Sorry. Moving on to the insanity defense. You heard me say Mr. Loyd's raised the defense of insanity.
Yes, sir.
That would be in the guilt phase when you're trying to decide whether or not he's guilty. The burden's on the defense. They have to prove it by clear and convincing evidence. If at the end of that part of the trial you believed that they had proven that Mr. Loyd was insane at the time of the offense, would you be able to return a verdict of not guilty?
Yes.
And lastly, can you follow my instruction to completely put out of your mind when deciding whether or not he's guilty in this case, the fact that he was convicted of the murder of Sade Dixon and her unborn child and sentenced to life?
Yes.
Do you have any doubts about any of this?
Not that I can think of, no.
All right, thank you, sir. State, you may inquire.
Thank you, Your Honor. Good afternoon, sir.
Good afternoon.
I think I know the answer, but I want to make sure. If we asked you to be here on the 23rd, was it a wedding?
Yeah, it's on the 24th.
24th.
Yes.
If we asked you to be here or for some other reason you couldn't be here, are you going to hold that against us or the defense or anybody else?
Oh, no, not personally. I understand
Okay.
it's important to...
You could still be fair and impartial even if we asked you to miss that?
Yeah, I wouldn't, try to, affect the outcome or in any way because of that.
Okay. When you filled out your juror questionnaire, when you were called back last week, there's a question on there that says, have you or any member of your family been accused, a complainant, or a witness in a criminal case? And you said yes. Can you tell me what you were answering yes to, or what that situation is?
Well, in my family history, I have a few uncles that have gotten into trouble before.
Okay.
And this was when I was a little younger. So I'm not quite sure what the details were, but I do know they did go to prison or they went to jail for some stuff they got into.
Okay. You don't know what they went to prison for or anything like that?
No, I was really little at the time.
Do you have relationships with them now?
I haven't spoken to my uncles in a couple of years now.
You have not spoken to
No,
them?
I have spoken to.
So they're your uncles, but you don't hang out or anything like that?
No.
Okay. Anything about their experience with the criminal justice system that you think would prevent you from being fair and impartial?
No, not necessarily, no.
Not necessarily. What do you mean, not necessarily?
I mean, because I guess I don't really know how they were treated, so I couldn't,
Okay,
yeah.
that's fair. So you, when you were answering the judge's questions about the death penalty or your thoughts on it, you sort of put yourself in a legislator's shoes.
Oh, yeah.
So, and I interpreted that as if you became a member of the Florida legislature and you had to vote, you would say, we don't need the death penalty.
Yeah, I would personally think it's not necessary, like if I was in that position. Just my own personal opinion.
And what about it is not necessary? Or what is it about the process, the outcome? Is it moral? Is it practical? Can you kind of tell me what your thinking would be? In other words, if let's just say you got elected, God forbid, in a year from now, and somebody asked you that question, how would you answer it?
I guess just in my, it's not like a vast knowledge, but in my limited knowledge and looking into it, I've seen like a lot of death penalty cases. What happens is that, they get stuck in like going for appeals and stuff, and it takes a very long time to even reach, that final action or whatever. So that was just one of the reasons why I was thinking like it's kind of inefficient, but so I wouldn't necessarily think that we would need it.
Okay.
For that reason.
So it's a practical consideration.
Yeah, the practicality of it. Yeah.
Is there any moral or religious objection that you have to it?
No.
Okay. Can you imagine the judge told you, but it was a while ago, that the only crime for which the death penalty is even an option is first-degree murder. You heard her say that?
Yes, I remember.
Typically, that means that it's a premeditated murder. You're nodding your head like you know what premeditated means.
Yeah, no,
Okay.
I'm a little familiar.
And I'm sorry, don't think I'm talking down to you. We talked to a lot of people, and I never know how much information they have. So, can you think of a set of circumstances where a person would commit a premeditated murder where you would believe that a sentence of death would be appropriate?
Could I think of a situation? Yeah.
Even what is a set of circumstances just based on your beliefs and background and the way you think? You say, yeah, this kind of murder, that's just beyond the pale, and I would think death is appropriate.
I suppose like if someone were to murder someone where they, in a premeditated murder, suppose if it was like a truly like defenseless, helpless person where, like an example, like children and stuff like that, where
children, you said?
Yeah.
Okay.
Like there's no like way for the person to have a chance. I feel like that kind of person would be really dangerous to society.
A person who would kill a helpless person.
Yeah.
And in your mind, and remember, this is just your opinion, okay?
This is my opinion, yeah.
In your mind, a person who murdered a helpless person, you could imagine a death being an appropriate sentence.
Yeah.
All right. Conversely, can you imagine even a premeditated murder where life in prison without the possibility of parole would be more appropriate to you than death?
Yes, I could imagine that.
Okay. Can you tell me what you're thinking when you say yes?
So, I mean, I guess, every situation is very, like, nuanced. It's not so cut and clear. But this situation that came to mind is, like, there's a premeditated murder, so you're gunning on doing it. and for whatever reason, you're going through with it. But then, there's like, I don't know, I guess in my head, the way it's playing out is like you're putting yourself in a position where you plan on killing someone. Let's say you have a beef, or like, you beef with someone. So you already got in your mind, maybe you've like written out your thoughts or whatever on what you wanted to do. But then since you're like in a feud with this person, they also are being violent towards you. So you end up killing this person in a situation where you guys are both fighting each other.
I see.
I don't know if that counts as premeditated murder, or you just in a conflict in the heat of the moment.
All I asked you was for a set of circumstances, and you gave me that very thing.
Okay.
So that's helpful. A situation where there was prior animosity between the two parties.
Right.
Okay. And correct me if I'm wrong, but it sounds like that's you looking at the circumstances surrounding the death.
Yes.
Okay. And believe it or not, with all that explanation that you got about the process, that is a very short version of the process, which is to say that if and only if there's a conviction of first-degree murder, you all will be given evidence about the aggravating factors, things that make a first-degree murder aggravated or heightened above one that doesn't have those factors. But you'll also be presented with evidence of mitigating circumstances, things about the crime or about the defendant and his background or life experience that would lead you to believe that life is appropriate rather than death. Anything about that process, as it's been explained to you and as we've discussed it, that you think you couldn't go through or that you couldn't participate in?
No.
Okay. On a scale of 1 to 10, with 1 being that you can't wait to get out of here, and 10 being that you can't wait to be a part of this jury, where would you say your desire to participate in this process is, 1 to 10?
I would say it's around a 7.
7.
Yes.
Okay, which is above 5. So why is it above the 5? Why is it more than maybe a normal or typical situation would be?
It'd be above because I am really fascinated about the concept of, justice and equal and fair trial.
Okay.
And I do like to look at, the surrounding evidence in any decision I try to make. So it feel like I'd be impartial if I were in those kind of decision-making processes. But it's only at 7 because of my...
You have a life?
No, not well. I'm a developer, so I stay in my house most of the time.
Okay.
But I did want to go to that wedding, so that's the
Right,
only thing in the back of my mind.
Okay. I appreciate your honesty. 2 more questions. Actually, no, 3 more questions. So the first question is, we've been talking hypothetically about the death penalty, but it's one thing to say that you could be a part of the process and vote to impose a sentence of death, and it's another thing to be a part of the process and to do it. So my question for you is, do you think that if the facts that needed to be proven were proven to you, and that you believed that death was the appropriate sentence, could you raise your hand in the jury room and then come out here as the verdict was read and the judge would ask people, is this your verdict? And could you have a verdict to impose a sentence of death upon another human being?
Yes.
All right. Conversely, if you thought that death was not appropriate or we hadn't proved what we needed to prove, could you recommend life even if the facts really irritated you and made you upset?
Yes, if that was, if what was presented went in that direction, yeah.
Yes, sir. All right. Do you have any personal experience, you or someone close to you, with mental illness?
Yes.
Can you, and I know this is a little uncomfortable because there's a lot of people in here, but can you tell us about that? I'm asking because of the insanity defense.
My closest experience would be just my mother.
Okay.
She has a lot of mental problems, so she has to, get help for that. So I do know I have a little experience with that. I'm not sure to what extent it would be considered like a diagnosed illness,
Sure.
but she does definitely have, mental problems.
Has she ever sought treatment to your knowledge?
Not officially. She gets help in her own ways. I guess out of not wanting to bring it up to like a doctor, she like gives her own diagnosis or whatever what's wrong with her, but it's mental illnesses mixed with legitimate medical problems that she has. So it's out of my scope of like knowledge, but she definitely has mental problems.
Has she been experiencing that? Well, did you grow up with her in the same household?
Yes.
Do you still live with her?
Yes.
All right. So has she been experiencing that during times when you live with her on a daily basis?
Yes.
Has that been hard for you to go through? I know that's a silly question. But
Yeah, sometimes, yeah.
Okay. So based upon your responses, I take it that you understand that mental illness is real.
Yes.
Okay. Anything about the experience with your mother that you think would prevent you from fairly and impartially weighing a defense of not guilty by reason of insanity?
No.
And just to be clear, when I say weighing, it's the defendant's burden to prove that. It's one of the rare situations where it's not our burden. Could you listen to the evidence they present and decide whether they've proven it based solely on the evidence, setting aside the experience that you've had with your mother in your life?
Yeah, I know. I'm very aware, that my mom's experience with me is just one experience out of a sea of many others.
Okay. Last question. Anything else about your past or background that you think we should know about, given that we're trying to select the most fair and impartial jury we can here?
Anything that I guess would be relevant to the selection? No?
Okay, and I didn't know that there was anything, and usually if there is, a light bulb goes off.
I guess what I would maybe consider is that, like I'm not registered Republican or Democrat, I'm just independent because I can't choose to align myself fully on one side, just because I usually just try to look at things on a case-by-case basis.
Okay, so there's two ways to interpret that. One way is, and you said can't choose, one way is that you can't make a decision. The other way that I'm interpreting it is that you don't wholly align with one group or another.
Yeah, I can't wholly align like all my ideas with one broad, side or anything like that.
Understood, and I appreciate you telling me that because that gives us some insight into who you are. So, okay, thank you very much, sir. Thank you, Your Honor.
How are you doing, sir?
I'm doing good, thank you.
So it was my understanding that the reason you, as a legislator, would not vote for the death penalty was because you didn't think it was efficient.
Yeah.
Okay. That's the only reason.
Yeah, I don't think it's efficient or practical. As far as I've looked up, those cases usually take it could be like years, decades for the sentence to actually go through.
Okay.
That'd be my reason.
Now, what do you think about the responsibility you would have if you were sitting on a jury involving the death penalty, the responsibility you would have about someone else's life? What are your thoughts on that?
It's a really big responsibility. And then I guess in this setting here, it'd only be fair to, go by what the expectations are, that if those factors are proven, then I should, go with that decision.
Okay.
Whether the factors be life in prison or death penalty, I feel like it's only fair to just go by whatever gets proven.
Okay. But I don't want to misunderstand what you're saying and interpret what you're saying is that you are a machine that's just going to follow the checks and balances along the responsibility. Is that who you are, or are you a human being?
I mean, I'm a human being. I do think I like a machine a lot just for my job. But I don't usually hold very strong opinions on things unless I personally like have some like knowledge on it, like at least a good amount of knowledge on it. So I guess in this case, that knowledge is just me hearing like both sides and what evidence they present. Until
Right.
then, I wouldn't have a strong opinion.
Right, right. But you can understand that the reason we're taking such a long time and talking to jurors is that we just don't want to herd in the first 12 and not who they are.
Right. No, that makes sense.
Do you think there's a reason for that?
Well, yeah, because it's someone's life is on the line.
Okay. You're right on point. Now I want to tell you a little bit about your responsibility if you become a juror in this case in regards to the death penalty, okay?
Okay.
So essentially, as you probably know, there will be no penalty phase unless Mr. Loyd is convicted of first-degree murder. You understand that?
Yes.
Okay. If he's convicted of first-degree murder, the state will put on additional evidence of what's called aggravating circumstances. Aggravating circumstances would come from this case also, and so there will be a group of aggravating circumstances. And then the defense would put on mitigation. Mitigation is anything in Mr. Loyd's life that mitigates against a death sentence. And so there will be experts testifying, family members testifying, things presented to you. Once that happens, you as a jury would have to decide as a group, and it's the only time you do anything as a group, you would have to decide whether one aggravating factor was proven beyond a reasonable doubt. If you all agree on that, then you would move to the next step. And the next step and all steps after only have to do with you and your responsibility. Because this is an individual sentencing process. Do you understand that?
Yeah.
You understand that it's your decision, not anyone else's. And no one can tell you what to do. You understand? Whatever your opinion is, no one can tell you what to do. It's your final opinion. Are you okay with that?
Yeah.
You think you're strong enough to deal with that? Okay. So you're not going to let anybody bully you?
No, no.
Okay. And if you see someone bullying someone else and it's right in front of you, are you going to kind of suggest that they stop?
Yeah. I mean, I at least from what I heard, that's what we should be doing.
Okay. Do you believe that? I mean, do you believe that it's an individual process?
Yeah.
Okay. So going back to your responsibility, so the next step is that you're going to have to weigh the aggravating factors. After you decide which aggravating factors were proven beyond a reasonable doubt. And then you would have to weigh the mitigating circumstances. They are proven at a threshold lesser than beyond a reasonable doubt. And once they're proven in your mind, then you're going to have to give weight to all that mitigation individually and collectively. And you would have to give weight to the aggravation individually and collectively. And essentially you have then two things that you have to weigh. You're the only one who gets to weigh that. It's your decision. So then you weigh that, and if the mitigation outweighs the aggravation, then you have to vote for life. You don't have a choice. If the aggravation outweighs the mitigation, then you may vote for death. But the law has a caveat. You are never required, under any circumstance, to vote for death if you don't want to. It's your decision. You'll hear that in the jury instructions. And the reason the legislator gave that to the jurors is because they want to allow the jurors to make, number one, individual decisions, and number two, to have an opportunity to grant mercy or what any other reason exists within the juror to not vote for death. They want that ability to occur with the jurors. You okay with that?
Yeah.
Okay, and then once that happens, each of the jurors will let their verdict be known. And if it's a unanimous decision, meaning every one of the jurors vote for death, then that would be a death verdict. If one juror votes for life, that's a life verdict. So all it takes is one. You understand that?
Yeah.
You understand how important it is? All it takes is one.
Mm-hmm.
Okay. And then there's going to be something called victim impact that's presented to you. And that is essentially anything that the state decides to introduce about Sergeant Clayton's life through witnesses. And there's a very structured approach to that because the statute says it's only about the uniqueness of Sergeant Clayton that can occur in court. And so people will give their opinions about her uniqueness in court, either by reading it or testifying to it. There may be pictures shown. But the legislator has made it clear that you can't use the victim impact testimony on the issue of whether Mr. Loyd is to get death or not. Understand that? Mm-hmm. So it can't be used. It could be considered by you as a juror, and of course everyone in the courtroom, but it can't be used in any form to vote for death. Can you follow the law?
Yes.
Okay. Thank you very much.
You're welcome.
No.
Okay.
Don't start calling until Friday after 5, and then call every day. Eventually, you'll hear the message. We won't need you for next week, all right?
Okay.
The day that you come back here, you need to bring a suitcase with you, prepared to go into sequestration. If your case is really supposed to be that day, definitely watch the car and help you through your life. But leave it in the car, don't bring it in the car.
Okay.
Not take it to the home.
Okay. So just to make sure that I know what the next steps is, I use what's in here, and I should call after next week.
No, Friday, this Friday.
Friday, this after 5 this Friday.
You call after 5. Monday, you call after 5. Tuesday, you call after 5. So you hear them tell you that the purple group needs to come back.
Okay.
And that's the day that you need to come with your suitcase packed and ready to go. In case you get
Okay. So if I call on, let's say, Tuesday after 5, and they say that the purple group needs to come, I come that same Tuesday?
No, they'll tell you to come in maybe Wednesday.
Oh, okay.
Usually we give you a day or two notice that we need to come in for final budget.
Okay.
Okay?
All right. No?
All right, thank you so much. Have a good day. Don't leave anything or cocktails like that.
Thank you.
You're in seat number 19.
Good afternoon. Doing good. Good. Thank you. Okay. Okay.
Not looking for any particular answers, looking for you to tell us what you actually think.
Okay.
Juror number
Correct. Correct. I do follow the local news somewhat, and I did have after Friday, I went in on yesterday, Monday, to work, and I had one of my coworkers comment to me that because I had been on jury duty, he said, "Well, watch that you get this case," and I said, "Don't tell me anything else." He didn't think it was. He had no idea, but yeah, that was right. Yes. 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 I think that it has its place in circumstances such as you described earlier, aggravating circumstances. Are there some cases that it would be automatic if that person's guilty? Yes. Cases that had other circumstances in addition to the murder. I think that if it involves anything that would involve a child and murder, anything that would involve some of the circumstances, possibly torture or things like that. Not automatically, no.
So I assume you have no moral or religious objections to that penalty based on it?
No.
You know what the process is. If, when there's a penalty phase, the state's going to present evidence of aggravating, the reasons they believe the death penalty is appropriate. That's going to present litigation. The reasons they believe that a life sentence without the possibility of parole is the appropriate sentence. I'll give you the jury instructions. We're going to go in that jury room and talk about this with your fellow jurors if you want. You actually don't have to. You all discuss it as much or as little as you want. We've not going to do it on the jury room. At the end, you've got to weigh the aggravators and mitigators, decide what weight you're giving to them. You have to look at all the evidence and facts, and mitigate the aggravators, and you have to decide for yourself whether or not it's life or death. So if at the end of all of that, you thought the appropriate sentence was life without the possibility of parole, you voted that.
Yes.
And if at the end of all of that, you thought death was the appropriate sentence, you voted for that.
Yes.
Do you have any doubts about your ability to go through that process?
I do not.
As I told you, Mr. Loyd has raised the defense of insanity at the time of the offense. And that's in the guilt phase, and we're all trying to decide whether or not he's guilty. So at the end of the guilt phase, words on the defense in that one. The only time words on the defense, they have to prove it by clear and convincing evidence. But let's assume at the end of that guilt phase, you were convinced that he wasn't insane at the time of the offense. Would you be able to go back?
Yes.
And lastly, can you follow my instruction that the murder of Ms. Dixon and her own child with a life sentence on that cannot be used to determine whether he's guilty in this case?
Yes, I can.
All right. Do you have any doubts about any of this?
I do not.
And do you have any issues that will prevent you from serving as a juror?
I have no issues. One thing I just wanted to make sure that I'm clear on Friday when we asked about if we knew anybody, there's only, and I don't know by name, and I'm not sure it's the correct person. I had one interaction one time, what I believe with the defense lawyer on the very end, my extreme left. kind of recognize the face, but don't recall the circumstances or anything like that. There is not. You're welcome.
Can we come sidebar first? Can we come sidebar?